Welcome back to Navigating Abundance. Today, our guest is a good friend of Chris Tanke, Strategic Financial Group, and Navigating Abundance, Ken Puzycki of Puzycki Law. Ken has been practicing law for 35 years and has worked in his own firm for 30 of those years. Ken works in a variety of legal areas, but primarily works in estate planning and administration. And this makes him the perfect candidate to discuss today's topic of beneficiaries and avoiding some heartache for your beneficiaries, particularly after you pass.
Welcome to the Navigating Abundance podcast. Our goal is to encourage you to pursue your total family wealth potential through insightful conversation with experts and thought leaders in their fields. But first, some obligatory disclosures. Navigating Abundance podcasts do not represent investment, legal, or tax advice. Any opinion expressed in Navigating Abundance podcast is solely those of Christopher Tanke and his guests and are based upon information believed to be reliable but not guaranteed. Podcasts are produced for educational and entertainment purposes only and should not be considered an endorsement of the guest or the views that they hold. Information shared may not be appropriate for your personal situation. Consult a qualified advisor for guidance. Investment advisory services are offered through Strategic Financial Group, LLC, a registered investment advisor. Navigating Abundance is a trademark of Strategic Financial Group, LLC. And now here's your host, Chris Tanke.
Welcome back to Navigating Abundance. I'm Chris Tanke, and again, just delighted to have the counselor of the hour, Ken Puzycki of Puzycki Law, a good friend of mine. And today it's a twofer. We're going to be talking about beneficiary designations and how to keep it straight and clear. And in the process of doing that, you just can't help it. You're going to get a Latin lesson. Isn't that true, Ken?
Latin. I think we can throw some Greek in there if you want.
We'll throw it together. Yeah.
Primarily, it's going to be Latin.
Yeah.
A lot of gibberish either way, but it's all really important stuff. We don't want your clients to be making mistakes because at the end of the day, you could have some really hurt beneficiaries.
That's for sure. And I will tell you, beneficiary designations, keeping track of it, keeping up to date with it, the intentions actually working out the way that at least you think they will. There are many times where that is not the case. And we've seen it even in the firm this last couple of months. We've had somebody come in that said, wow, here's how my trust is set up. And they were like tranching how it would give certain amounts over certain periods of time, starting at age 35. And it's lovely and everything. The problem is the accounts of the beneficiaries were not the trust. And I said, the beneficiaries are the children direct. It's not the trust. And so if you were to predecease them, that's not going in the trust. And all that you set up for the dissemination of things intelligently, it'll never happen. Not with these assets.
Right.
They couldn't believe it. So that kind of stuff, and you've seen it too, Ken, is what we super want to avoid because, you have your life poured into this. You want to make sure that it gets where you want it to go, when you want it to go, et cetera. And it is very easy to make an assumption or to miss something. And that's why we're bringing this presentation to you guys today.
And as is typical, you jumped into the deep end, my friend.
That's what I do.
Yeah, that's what you do. So you mentioned the T word, the word trust.
Yeah.
And some of your clients might have a trust. I would gather, though, that most of them do not. So what we're going to do is we're going to back way up. And we're going to talk about some principles that apply whether you have a trust or whether you don't have a trust. So this discussion is going to start out talking about anybody who has an IRA or a life insurance policy or a 401k or a TOD account or a trust. It applies to everybody. Mm-hmm. So you do a fair amount of 401k rollovers, correct?
Mm-hmm. Yes.
So your Schwab beneficiary form has certain default options available when somebody fills out the beneficiary form. Schwab has default distribution formulas. Merrill Lynch has default beneficiary formulas. Every company has its own default beneficiary form. So regardless of where, the listener here might have their accounts, it's really, really important to look at your beneficiary form. Because your kids and your grandkids could really be disappointed if you check the wrong box or if you don't fill out the beneficiary form correctly.
Yes, and they differentiate from company to company, and some of them we've seen have said, "Look, this is how we handle per stirpes," and we'll be discussing this. if your state, and you're an attorney, you can tell me if they can get away with this. If your state has a different view of that, it doesn't matter. You signed this and you said this is how you want to have it happen.
Yeah. So case in point, let's say you've got a beneficiary form through Schwab. And where are they headquartered? Massachusetts?
I think, are they in, they're in Florida now, aren't they?
I
think they're in Florida.
Yeah, like today, let's pick Florida, right?
Okay.
So let's assume that their corporate headquarters are in Florida. Well, Florida might have a different interpretation of what per stirpes means or what capita means. Because after you invited me on, I did my homework and I started doing some research on what per capita. I know what per capita means under Michigan law, but it turns out per capita means various different things depending on what state you're in. And depending on what company you're with, if you're with Schwab and they're in Florida and you've got per capita, that they're going to use the Florida definition of per capita, not the Michigan definition of per capita.
That's right.
But before we get into those weeds,
let me just say that. Hang on a second. So what we've done is we've thoroughly scared the bejeebers out of you so far in this first 5 minutes, which is good. Case in point, trust but verify what your intentions are, and don't just trust an attorney as handsome as they are. Make sure that when you bring the design from the attorney, you bring it to your other counselors and say, look this over, and have them converse with each other, because sometimes things are missed. It's just, you need a team. You really need a team, especially if these are significant assets with significant consequences then going to your beneficiaries. It's just, it's a sticky wicket. It's not always as simple, especially with significant dollars, as you think it might be. So that's what this is about, right? So there is hope. Don't jump off the cliff. It's fine, but at least we want to get you the basics to this here and understand. First of all, it's serious business, easy to mess up, and make sure that you trust but verify with what your intentions. How does this really work? Talk through to the counselor. If this happens and this happens and this, talk it through.
Amen, brother. Amen.
And that's what we're going to do. So, all right.
So when somebody comes into my office and they say, hey, Ken, I want a will. Hey, Ken, I want a trust. Or if they come into your office and say, hey, we want to take our $5 million 401k and roll it into an IRA. One of the first things you probably do when you set up that rollover IRA is you present them with the beneficiary form, right? Just like when somebody comes into me for a trust. One of the first things I ask them is, when you pass away, let's pick a simple situation where you've got a widow, let's call it a grandmother, right? Grandma's widowed, her husband died a few years back, and she's got 4 kids. Pretty generic situation. I would ask, if you died yesterday, Eleanor, where would you want your estate to go? And 99 times out of 100, what does she say? To my kids, right? To my kids. Just like when you fill out the beneficiary form. You say, Eleanor, when you die, where do you want your IRA to go? And she said, I want it to go to my kids. Now, some beneficiary forms, all you have to do is say, my children. You don't have to name them by name. Some beneficiary forms require you to put child 1, child 2, child 3, child 4. Okay, it depends on the company. Okay, and that's the easy scenario. And I'm going to throw up a slide here, and you can see that in this scenario, Grandma's got a $12 million estate. She's got 4 kids, A, B, C, and D, right? And 2 of those kids might have children. In fact, in this situation, Abby's got 3 kids, and her son has 2 children. But all 4 kids are alive when Eleanor passes away. That's easy. Okay. So if Grandma lists all 4 children on the beneficiary form, or if Grandma says my children on the beneficiary form, or if in the trust says my 4 children by name, that's an easy scenario. That there's no issues there.
No Latin necessary.
No Latin necessary. Now, the problem arises when one of the kids predeceases Eleanor, right? So if one of the kids predeceases Eleanor, now we have options. And this is where people can go, they can check the wrong box and really hurt people. Some beneficiary forms, I'd say a minority of the beneficiary forms, give everything to the surviving named beneficiary. So if you have 4 beneficiaries and one of them dies, the 3 survivors get everything. Even if the deceased child has surviving children, if Eleanor has grandkids and that child dies, in this case, if Abby dies before Eleanor, if your beneficiary form says we give it to the surviving beneficiaries, Abby's kids are going to get nothing because that's what the beneficiary form says. And in that scenario, most people would be very hurt when grandma dies to find out that Abby's 3 children are getting nothing. So I've had situations where clients want things to go to the survivors and not trickle down to the grandkids. But that's why it's important for you and for me to ask that difficult question. Eleanor, what happens if Abby dies before you? Where do you want her share to go? And typically she said, well, give it to the grandkids. Okay. Now, and that's where it's up to me. That's where it's up to you to know which box to check and to know what language to put in the beneficiary form or in the trust or in the case of a will. What about all these Latin words, per stirpes, per capita? That's where things get a little funky. And there are basically 3 options here. There's per stirpes, there's per capita with representation or by generation. And then the third option is per capita without any parameters around it. Now, so if Abby dies before grandma, Abby's got 3 surviving children, and the beneficiary form defaults to per stirpes, that's what I refer to as trickle down. If Abby dies, her share, her quarter will trickle down to her 3 children, and each of them will receive 1/3 of her quarter. So each of them will receive 1/12 of the estate or the IRA, depending on the situation. Okay. By contrast, if the form defaults to per capita by generation or per capita without any delineation, that's where we really start to see the stark differences. If the default beneficiary is per capita by generation, we have exactly the same outcome as per stirpes. Abby dies, her 3 kids will take her share, and each of them will receive 1/3 of their mother's share. Okay? Now, if the beneficiary form defaults to per capita without any parameters around it, not by generation, not by representation, just per capita. And this is the mistake that I see in trusts and wills. A lot of times, trusts and wills that are downloaded off the internet. If the will says per capita and does not say per capita by generation or per capita by representation, we have a very awkward outcome, because if you simply say per capita, what happens is at the end of the day, when an Eleanor dies, the executor of the estate counts heads. And in this scenario, died before her mother. Abby died before Eleanor. Abby's got 3 children surviving, and Eleanor has 3 other children surviving. So how many heads do we have? The 3 surviving children of Eleanor and the 3 surviving children of Abby. There's 6 heads. So all 6 of those beneficiaries would get an equal share. And a lot of times that is not what the client wants. The clients typically want things to trickle down to the beneficiaries based on children and grandchildren, and the grandchildren would only receive a fraction of what their parent would have received if they had survived.
And that is sort of the spirit behind a per stirpes or per branch idea.
Yes.
Is that my share, 3 children, my third, if I predecease, would go to my kids, and in a variety of ways. We'll talk about different ways that could happen. So yeah, the danger potentially of a straight per capita can be really significant, and it's probably one of the most common things that we see.
Yes, especially with forms that are downloaded off the internet. And I've seen beneficiary forms, and they have a little box that says per capita.
Yep, we do too.
And per capita means count the heads. When grandma dies, you count the heads of the living beneficiaries, and you divide by that number of living beneficiaries. And that's a lot of times where, again, some people are hurt and some people are benefited. But ultimately, what is the question? What did the client want? And that's where you and I need to understand the difference between per capita by representation, per stirpes, to know the difference so that we can tell the client which of those magic Latin phrases we need to put into the trust or the will, or which box we need to check on the beneficiary form. Okay?
Very good.
Now, so this concept of per stirpes you use by the branch, and it's very descriptive, and it's really illustrated when you've got two children who might pass away before Eleanor. So we've got a slide here where Eleanor, she still has the same $12 million estate. She's got the same 4 children, but this time the oldest and youngest both predecease her. And Abby, she's still got 3 kids, but the other child that passed away has 2 children rather than 3. And this is where, again, if the client wants things to trickle down, Abby's children will divide their mother's share, their mother's quarter, but the children of the other deceased child, David's share would go to his 2 children if it is per stirpes. Per stirpes is by branch, trickle down, whatever name you want to put on it. And this is what most people want. Most people want the deceased child's share to trickle down to their respective children and have things distributed accordingly.
I would just say though, and that's fine, and that's there is nothing wrong with that. Essentially, your share of my primary beneficiaries, that were, of my children, your share is going to go to your descendants, no matter how many there are. But you have to understand, though, that there might be a conversation at Grandma's funeral where one of the children say, "Wow, I can't believe she did a fabulous job, and gosh, we ended up with $1.5 million. Can you believe it? What are you going to do with your $1.5 million?" The other grandchild says, "What do you mean $1.5 million?
Yeah.
What do you mean $1.5 million? Well, I got $1 million. Okay. Right. Well, gee, I guess Grandma didn't. What did I do wrong? The point is that sort of thing can and will happen, and so you have to understand, or make it clear, I would say ahead of time, that no, I'm going to divide it up per primary beneficiaries, and your share will go to your children if you predecease me, divided by how many they are. And that's what I think is the fairest thing to do. Now, that can be debatable, but
it's up to the client.
It's up to the client. That's right. That's exactly right.
Because you hit the nail on the head. A lot of clients look at it from, what do each of the living children get? And we want those to be the same. And what do each of the living grandchildren get? If their parent predeceases, like the slide here says, if Abby dies and David dies, and they got 5 grandkids now who are alive, and they get together over ham on bun after the funeral, and they look at each other and say, "Hey, what are you getting?" And as you pointed out, if David's kids say, "Hey, we're getting $1.5 million," and Abby's kids go, "Whoa, we're only getting $1 million," that could create some dissension between the grandkids. And it's, again, there's no right or wrong. There's no fair or unfair. It's really what Eleanor wanted.
And in that scenario, we know David's going to pick up the check for lunch.
There you go. But the difference there is per capita versus per stirpes.
Yes.
Okay. And so for those that are watching this, if you're filling out your own beneficiary form, or if you're meeting with your lawyer ahead of time, if you know the difference between per capita and per stirpes, you're a leg up. Because a lot of times I find myself discussing these options while the client is here, and they need to think about that. They need to think about it.
Yeah.
Now, the again, this is per stirpes. Per stirpes is trickle it down. What if grandma wants to treat the kids, the grandchildren, equally? Well, there you choose per capita by representation, not per capita alone, but per capita by representation. What does that mean? That means that we're going to take Abby's share and David's share and lump them together. And then we're going to divide that double share amongst all 5 of the grandchildren equally. That way, when they're eating ham on bun after the funeral, each of those 5 grandkids gets the same amount. So if Eleanor wants the grandkids to be treated equally and the living children to be treated equally, she would say, I want per capita by representation. And interestingly, that is the new default in Michigan. We used to be a per stirpe state. Now we are a by right of representation state. And so we would lump the 2 deceased kids together. We would divide it amongst their collective children and divide it equally amongst those grandchildren.
So could you help us understand now? So you say it's the new default in Michigan. We've already established that somebody signed a custodial form that said, Michigan, I live there. It doesn't really matter. This is how I want it done. And that will trump. At what point does the default in Michigan, at what point is it applied?
It's only a default if the beneficiary form is silent.
Oh, my.
So, right.
I would never imagine that could happen. Okay, but all right.
You can always override. I try not to use the word Trump in public, but you can always override.
That was good.
You can always override the default. So how do you override the default? Well, you can actually write per stirpes by representation, or if you have a trust, you can name your trust as the beneficiary, and then the trust instrument will divide things according to your wishes.
Okay.
And there you can really get creative.
Right.
Because all these slides that we've got, you'll notice who's conspicuously absent from these slides. Abby's spouse. What if Abby dies? She's got 3 kids, but she's got a surviving husband. Well, none of the default boxes that you check on a beneficiary form, per stirpes, per capita by representation, per capita by generation, none of them include a surviving spouse. Why? They're not blood. So most of the default check the box options that you've got ignore a surviving spouse because they're not blood relation.
Yes.
So what if Eleanor wants to leave Abby's share to her surviving husband? Well, she's going to have to either write that specifically in the beneficiary form, which you can do. Most beneficiary forms will have primary beneficiaries and secondary beneficiaries. And you can actually denote that if Abby dies before Eleanor, that her share will go not to her 3 children, but to her husband, or a combination. It's very common for clients to say, hey, if Abby dies before I do, I want to give a share to her husband, George, and a share to each of the 3 grandchildren. So each of those beneficiaries will receive 1/4 of Abby's share. But that takes a little artwork in the beneficiary form or in the will or the trust. And that's where it's up to the attorney and up to the financial planner to offer assistance to the client. And again, this is interesting. When I give seminars, a lot of times one of the icebreaker questions that I ask is, all right, I need a show of hands. Who has not done any estate planning? And every so often I'll get 3 or 4 hands that pop up, and I'll pick on one of them, the most gullible, and I'll say, okay, I'm going to challenge you. I bet you have done some estate planning. And they go, no, I got nothing. I said, so you don't have a will? Nope, don't have a will. You don't have a trust? Nope, don't have a trust. Do you have an IRA? Oh, yeah. Did you fill out a beneficiary form? Yeah. I said, that's estate planning. And they go, oh, yeah, I suppose it is. Or if you have life insurance, you've got beneficiaries. That's estate planning. Or you've got a joint bank account with your son or daughter. That's estate planning. It's dangerous estate planning, but that's estate planning.
Might not be thorough enough, but yeah.
Or if you on a home with your spouse, that's estate planning.
Right.
And that's where you start picking each asset apart and say, okay, where do you want the house to go? Where do you want the bank account to go? Where do you want the IRA to go? Where do you want the life insurance to go? And the biggest takeaway from all of this is if you have a trust or if you have a will, those you can throw out the window if you haven't filled out the beneficiaries form correctly. Because you could have a trust that leaves everything to charity. But if you've got your kids named as the beneficiaries, the IRA beneficiary form, and you die, guess who's going to get that IRA?
It'll never trickle into the trust.
It'll never get there.
Yeah.
So the kids end up getting it contrary to mom and dad's wishes. So if you have a very well-tailored trust that does all kinds of fun stuff, giving money to grandkids and nieces and nephews and your favorite financial planner and your favorite lawyer, everybody gets a piece of the pie. But if you've got the kids named as the beneficiaries, it ain't going to happen.
That's right.
It ain't going to happen. And that's where people get hurt, because I've had situations where usually it's a young couple. One child is born and the wife beats the husband over the head to get a $500,000 life insurance policy. So if he dies, the house is paid for and the kid's education is paid for. So he very dutifully goes out and gets $500,000 life insurance policy. Who do you think he would name as the primary beneficiary? His wife. Who do you think he puts down as the secondary beneficiary? That child. So if you have a young couple and they have a son, Gavin is their only son at that point. Husband names wife as a primary beneficiary, Gavin is a secondary beneficiary. Well enough. But then they start having 2, 3, 4 kids. If he doesn't change the beneficiary form, you could have a potential headache at the end of the day.
All right. So one of the lessons that we're learning, and is really important to understand, is it's very, very important to have an ongoing relationship that's current with your counsel, because life changes a lot, right? And say one of your children tick you off. Well, you might have to redo your beneficiary form, or you remarried, or
change jobs.
You change jobs, yep. Or all of a sudden, let's say that yes, you know what, my son really loves the hunting property. I'm going to give him that, and it's worth $1 million. And you did that 20 years ago. My other son, I'm going to give $1 million IRA, and that's great. And so it kind of keep things equal at the moment. 20 years ago, that was true. The problem is when you're pushing up daisies, the property's worth $1 million too, and the IRA is worth $4 million.
Right.
And then they're like, hey, what? That's why you have to keep current with counsel, that you can understand what they're saying, and that you're regularly checking in with if it's a sizable account. That's just smart.
And that also involves you, because we're 2 legs of that 3-legged stool. You've got the financial planner, you've got the attorney, and you've got the CPA. Because the interesting thing about your scenario is if you've got 2 assets and you've got 2 kids and you die, there's $1 million in that hunting property that you're so fond of, and there's $1 million IRA. Are those equal?
No. One receives a step-up value and the other is taxed.
Right. So one of the things I used to do at Grand Valley when I taught there is I would adopt 6 or 7 students in the front row, and I would adopt them for a day. And I say, okay, guys, I'm the patriarch here. I died, and I've got an estate worth $1.2 million. And I've got 7 assets, each of which are worth $200,000. I've got a bank account. I've got a highly appreciated stock portfolio. I've got a condominium. I've got some life insurance. I've got a traditional IRA, and I've got a Roth IRA. And then I tell them, discuss amongst yourselves who gets which of those assets. And you can't take half and half. You have to take one of those 7 assets, each of which are worth $200,000, discuss which one you would want and why. And again, it just illustrates a piece of property might be worth $200,000. But if you want to sell it, you got to pay broker fees and that kind of stuff. But as you pointed out, Chris, that IRA, if you cash that sucker in, you got to pay income tax on it. What about the life insurance? There's no tax consequences. The bank account, there's no tax consequences. What about the Roth? The Roth is the one you want, right? Roth, you've got 10 years worth of tax-free growth where you could keep that money invested in the Roth and not have
and then put it in a non-qualified account if you wanted to.
Right. Because there's no tax on that Roth. You could have, assuming you got 8, 9, 10% annual growth in that fund over at 10 years, you've doubled your money.
Yeah. Yeah.
Anyway, take the Roth.
That's good. That's good.
Take the Roth. Yeah. Now, that all presupposes that the beneficiary forms are set up correctly and or everything is in the trust. Because if something is left out of the trust, you've got problems. And we actually get involved in this from time to time. And believe me, it gets ugly. Because what if you've got a very well-drafted trust that divides everything between the 4 kids, like Eleanor? She's got a trust, and the trust says, divide everything between my children per stirpes, and everything goes exactly where she wants it to go. But she puts her daughter's name, she puts Abby's name on that joint bank account. When Eleanor dies, who gets that bank account? Daughter. She's a joint owner. Eleanor dies. Abby walks away with whatever the balance is in that account.
Right.
Now, the other 3 kids are saying, whoa, Abby, the trust says divide everything at equal quarters. And Abby says, well, my lawyer says that this account belongs to me. It's not part of the trust.
That's right.
So Abby could argue, I get a quarter of the trust and I get that bank account because mom had my name on it. She must have loved me best.
Yeah, that's right.
And then a lot of times they'll say, well, that's the Smothers Brothers, right? And the clients under 50 don't know who I'm talking about. And the others do. Mom always loved you best. But those are the things that create problems after grandma dies. And to your point, that's why you need to sit down periodically. Unlike yourself, where you should be meeting with your clients, couple, 3, maybe 4 times a year, depending on the client's interest in the investments. But with an attorney, and you've got an estate plan, you want to be sitting down with that lawyer at least every 5 years, or as life changes happen. A death in the family, one spouse gets divorced, one of the spouses comes into an inheritance.
Right. Or you retire and roll out significant qualified funds.
Yeah.
Again, now there's the danger of the beneficiary form being wrong that doesn't sync with the trust. And
Exactly right. And there needs to be a coordination. And that involves me. That involves you. That involves those beneficiary forms. That involves those other assets outside. They downsided from a rancher on 3 acres to a condominium downtown. Make sure that condominium is titled in the name of the trust. If you've switched banks, as banks are inclined to do, make sure that the new bank has the proper beneficiary forms on it or the proper owners. Now, what we like to do, and other attorneys have done this, I didn't invent it, is within the trust document itself, the trust will say, upon my death, divide everything equally between my 4 children. And oh, by the way, if I have put one of my kids on the bank account as a convenience so they can pay my bills, when I die, even though that's not a trust asset, we want it to be treated as if it's part of the trust. That way, at the end of the day, it's just like Christmas morning when the kids were young, all of the 4 piles of assets are going to be equal. And nobody can look at the other person and say, oh, you got more than I did. Because those are the things that drive attorneys nuts. I don't like doing probate litigation because usually it's after mom and dad are dead and gone and the kids are just butting heads. So part of my job, part of my moral responsibility is to keep that infighting to a minimum at the end of the day. And that includes making sure that the beneficiary forms are filled out correctly, and includes making sure that the trust or the will is done correctly, and making sure that we coordinate all of their assets so that things go where they want them to go in the appropriate manner.
Yes, very, very important. And again, that requires good counsel, and that requires continual contact, because life changes, and that's just what you have to do. And that's, we call this navigating abundance. If you didn't have an abundance to navigate, then it's a lot simpler. But there is some complexity if you've been blessed. There's a stewardship to this, and it's gonna take some thought, and that's okay. Your family's worth it. You should be doing that.
Yep.
Yeah, that's what the law is for. And whatever you're dreaming about doing with your succession plan or your beneficiary plan, you can greatly increase the odds of it happening if you just have some care and some counsel to get it set up in the proper way. And that's kind of what we're going to bat for. Yeah. Kenneth, do you have any closing? I mean, that's my big closing remark. You know?
Amen. So, and we'll talk about some tax ramifications of naming a trust as a beneficiary of an IRA and in some further episode here. But we're between holidays here. Merry Christmas, by the way.
Oh, thank you.
So this is the end of the year. This is December 31st.
Mm-hmm. It is.
And the time for year-end giving is very, very quickly coming to a halt.
Mm-hmm.
But for those people that are charitably inclined, I'll wrap it up by saying this. If your will or your trust has a provision in it for a distribution to charity, to the church, to the university, feeding the homeless, whatever you want to do, you want to make sure that you explain that to your attorney or your financial planner, because, again, beneficiary forms come into play. Mm-hmm. Because if you're going to give assets to charity, goes back to my Grand Valley example, which assets do you want to give to charity? Remember, I described those 6 or 7 kids in the front row. What if one of those 7 is a charity rather than a child? You've got a charitable beneficiary. Now, which asset do you want to give to charity?
Yeah, your IRA is going that way.
Absolutely. For the same reason that you didn't want, that the kids didn't want it, is the reason why the charities would want it, because charities don't pay the tax.
Right.
And so a lot of times clients will come in and they say, yep, we want to divide things amongst the kids, but we want to treat the church the same as if we had a 5th child. So mm-hmm. rather than dividing everything in quarters, we want to go a 5th, a 5th, a 5th, a 5th. And I say, that's wonderful. And I ask them, which 5th of your estate would you like to give them? The most common response? I don't care. I'm dead. Right? And I say, well, yes, you may not care, but your kids will care. Because if your kids have a choice between receiving taxable IRA assets versus non-taxable stepped up in basis stock portfolio assets, they're going to want the tax-free stuff, give the taxable stuff to the church.
Mm-hmm.
And oftentimes that involves naming a charity as the beneficiary or a partial beneficiary on your IRAs, 401ks, or in your trust instrument. That's where it really gets. This is not simple stuff. Latin notwithstanding, this is not simple stuff. It's not horribly complicated, but that's where you need to sit down with a good advisor, a good attorney who can walk through each of your assets, look at the landscape, and make educated recommendations to the client on what to do and how to fill that beneficiary form out.
Because the unintended consequences of not doing that is very often significant. So you want to avoid that. Get good counsel, trust but verify, explain clearly what you want to have happening, have that counsel parrot it back to you. If we do it this way, this is what would happen. Is this what you want? And make sure that you keep it current.
And coordinate it with the planner, coordinate it with the accountant, coordinate it with the attorney.
Yep.
And that's what we're here for. Again, we're a team. We all want what the client wants. And between the 3 of us, between you and me and the CPA, the plan can happen.
Yep.
It has to be deliberate. It has to be deliberate.
Yep. Takes a team for sure. For sure. Well, Kenneth, thank you very much. Appreciate your time. And it's Christmas Eve, or will be shortly. And I wish you an awesome 2026. May you catch many fish and be in good health and continue to make a difference with people that you serve. We certainly appreciate you, my friend.
Same back to you, pal. Same back to you.
All right. Okay. Take care, guys. For Navigating Abundance, this is Chris Tanke signing out. Your family is worth it. Happy New Year.
Thank you for joining us for today's episode of Navigating Abundance. If you enjoyed this content and you'd like to see more of it in the future, please consider subscribing. If you'd like to join the conversation, leave a comment below on whatever platform that you're watching on. And if you'd like to learn more about Navigating Abundance, visit us at navigatingabundance.com.